London in computer science, in computer and telecommunications. He's currently a deputy director at the National Information Technology Development Agency, NITDA, and the head of the legal department. It's no wonder that he's the one coming to share with us about ODR and data protection because of his interest in emerging technologies and video games. Without much ado, we have all seen Mr. Edet's profile from the meeting invite. I would not want to eat into the time for the webinar. So Mr. Edet, the floor is yours.
Thank you so much, Morenike. I hope you permit me to call you that.
Yes.
And thank you. Thank you everyone for joining us. My name again is Emmanuel Edet. I work at the National Information Technology Development Agency, NITDA. I have been privileged to be part of policy making in the area of information technology for the past 20 years since I've worked in NITDA. I've been part of the team that developed the cybersecurity policy. I was also part of the team that also developed the Data Protection Act. I've also been privileged to deal with a few other legislations and issues that have to do with where law intersects with technology and how Nigeria can address such issues. Currently, we are dealing with emerging technology. And so for me, that's a new area that's exciting for us. Recently, we tried to develop what we call the code of practice for interactive computer platform providers here in Nigeria, which basically is a buzzword for trying to handle issues that has to do with social media, because we had received a lot of complaints about content on social media that may violate Nigerian law, even though a lot of these social media companies are not based in Nigeria. And so we had to engage them and have a discussion. So I'm just trying to give a background on some of the work we do here in NITDA and how we try as much as possible to contribute towards the development of the use of digital economy. And so ODR is another area where we are absolutely interested in, even though we may not be the primary agency in charge of dispute resolution as far as Nigeria is concerned, but we would like to work with everybody as much as possible to ensure that it's more convenient for Nigerians to use digital means and technology to carry out commercial activities. So if you would permit me, I'll just share my screen and go straight into the presentation. I heard I've been given 45 minutes. I am not sure I'll be able to talk for 45 minutes, but I am sure we'll get along just fine. And so it will be okay. Just to confirm, please, can you see my screen? Okay, yes. Thank you very much. All right, thank you very much. So I'll just want to discuss a few things about best practices for data protection in online dispute resolution. And without much ado, we all recognize the fact that over the past few years, not necessarily years per se, electronic commerce has become one of the mainstay of transactions in the world, all over the world. Within Nigeria, outside Nigeria, across borders, there has been several commercial transactions that have taken place, and this has resulted in a lot of convenience for consumers, I would say. But however, sometimes issues arise as a result of these transactions. Some of the issues are intentional mistakes, and there's always a need for these issues to be resolved. Of course, it's a bit difficult when you're dealing with cross-border transactions, because at some point jurisdiction has a role to play as far as these transactions are concerned. And so to ensure that all parties feel safe, there has to be some form of mechanism to resolve issues that arise, just like in the offline environments, where there are lots of issues that come up as a result of transactions, and you sometimes have to go to court or apply alternative dispute resolutions when you're dealing with issues that have to do with the protection of people's interests. So also in the online environment, you have this opportunity for people to carry out transactions, and so there should be opportunity for people to resolve their issues in that same environment without necessarily having to go outside that environment, because it's going to cost a lot. It's going to bring a lot of challenges to those who want to carry out this transaction. And so in 1999, the OECD published guidelines for consumer protection within the context of electronic commerce. I think that was the initial conception of rules governing protection of people in an online environment. And so these guidelines encourage businesses, consumer representatives, and governments to work together, that is within the EU, to provide consumers with meaningful access to fair and timely alternative dispute resolution and redress without undue cost burden. And technically speaking, the easiest way for you to deal with that definitely is an online dispute resolution mechanism, because as it is today, the online environment and technology itself has brought down the cost of so many things, from academic experiences to health to carrying out transactions, which is what we are talking about today. Everything has become cheaper. So why not make it possible for dispute resolution to be far cheaper than it is in an offline environment? And so this was one of the first set of guidelines. And so special attention was given to cross-border transaction, with special emphasis placed on innovative use of technology in implementing alternative dispute resolution systems. And so we now had a situation where people were encouraged to use automated means to deal with dispute resolution when you talk about international commerce. Of course, this, I believe that most people here already know what online dispute resolution is, which is basically a form of ADR that uses online tools as alternative methods for dispute resolution, partially or fully settled over the internet, having been initiated in cyberspace with various activities based on that particular space. But sometimes the hybrid version, especially when parties are in the same country, it's easier for you to go offline and resolve some issues, even though you either initiated it online or you initiated it offline and finished it online. So that's just basically what ODR is. People call it different names. Some call it electronic dispute resolution. Some call it ICT-based dispute resolution, but whatever it's called, as long as you have deployed technology to facilitate your dispute resolution, either wholly or partially, I believe that should be called an online dispute resolution. So coming to Nigeria, it's been interesting because in recent times, we've had laws that tend to support the use of technology, and using this technology for commercial activities has also produced new sets of circumstances that tend to cause inconvenience to citizens. As a rule of thumb, people prefer to use technology as long as it is convenient, and that's what happens. So once emerging technology comes into play, people will adopt it, use it, and but when there is a blowback, that is when the law now steps in and you identify the need to address certain issues that affect people, especially if they are citizens of your country. One of such review laws that we had in the near recent time is the Federal Competition and Consumer Protection Act, which basically established the Federal Competition and Consumer Protection Commission. Now, that commission has identified the need for use of alternative dispute resolutions to dispense with consumer issues. I think specifically that's in section 151 of that act. Then recently also we had the Arbitration Act, which basically overhauled the rules of arbitration, and the Evidence Act 2011 provides for admissibility of electronic evidence, which means that in every transaction, you can actually use electronic means to dispense with whatever issue that you have. And so a combination of these three acts, amongst other laws in the country, has provided legal support for the use of ADR to resolve issues regarding consumer complaints, provide legal status for including procedures and enforcement, and then also admissibility of electronic evidence, which was one of the
Hello, Mr. Edet, are you still here? Can everybody else hear him?
No, he froze, I think.
I think it's his network.
Yeah.
Exactly. Can't hear him.
He'll come back to us.
Yeah.
Very well.
Uh-oh.
I couldn't agree more with what he's saying.
Can you call him on his we'll see. I think he left the meeting completely. Okay, he's back now.
He's back, yeah.
Oh, I'm so sorry. I did not leave the meeting. The Zoom just froze, and my internet is working very fine. I guess it's one of those issues that come up once in a while. So yeah. I think I will just reshare my screen.
Okay, then.
Okay. So I guess I'm back. All right, thank you very much. So as you well know, in an offline environment, transactions are based on knowing your customers, as we normally say it in regulatory parlance, know your customer. You need to know those you are having conversations with. But in an online environment, everybody is reduced to bits and bytes. So you're basically a digit in the online environment, and you need to have proof of identity. And when you're talking about proof of identity, that's where your personal data comes into view, because your personal data is that data that identifies you in a unique manner. And protection of personal data is an issue that has come to the fore. In line with the provisions of the Constitution that actually provides for privacy of individuals in their homes. So the issue here would be this. For you to have interaction in an online environment, you need to provide certain data that will create your identity. And once those data, or once that data is taken from you, most of the time, because of the nature of electronic communications, it can be duplicated, it can be changed, it can be modified, and sometimes it can even be sold for certain amount of money or used in various commercial transactions without your consent, because once it goes online, it becomes easier to use and easier to actually manipulate. And so the concept of data protection came in several decades ago in order to ensure that personal data that is shared online will actually be protected irrespective of the circumstance. The essence of the protection of personal data is not necessarily to stop people from using personal data, but basically to use that data in a very responsible way that it does not cause harm to the original data subject. And so the concept of data protection is just basically to ensure security and privacy of your personal data. You have the technical aspects, which includes encryption, network security, access control, breach response, activity monitoring. And then there are also the aspect that has to do with enforcement of policies around how this data is used. The EU provided the General Data Protection Regulation, which was the most comprehensive attempt to protect personal data in the online environment. And it served as a flagship for various countries across the world to determine how personal data of their citizens are used, especially in an online environment. So today you have a situation where big tech companies are absolutely in charge of personal data. And as one of my good friends, Hakeem Ajijola, would say, if the product is free, you're probably the currency being used to pay for it. So personal data is being harvested for use in order to ensure that transactions are carried out. So how do we determine what constitutes personal data? It's just data that can identify you, like your name, your address, your phone number, birthplace, birth date, photo, email address, personal info, bio, accounting and financial information, geographical information, any type of information that can actually allow people to pinpoint you. And this is totally different from non-personal data. Non-personal data are regular data that can be reused for the purpose of delivering services. For example, geographical data, cultural, scientific, and other types of data that are not designed to identify human beings and persons. So taking a step back to ODR now, in an online dispute resolution activity, there is definitely a need to identify the people who are actually participating in this dispute resolution. So from your complainant to the platform to who is being complained about. I think eBay was one of the pioneers in online dispute resolution, considering the level of e-commerce which they had over the years. So you are now required to share your personal information to third parties and fourth parties, because during my research to speak on this, I read somewhere that an author claims that the technology is a fourth party as far as dispute resolution is concerned. I find it difficult in law to allocate partyship to a non-living thing, but for argument's sake, let's say the technology with artificial intelligence these days can be considered as a fourth party as far as these issues are concerned. And so your data will definitely be shared amongst all the parties in any online dispute resolution scenario. So the question would be, what are the rules of engagement, which is basically the crux of this conversation? What are the rules of engagement as far as data protection is concerned when you share your personal data with people that are supposed to help you resolve your issue? Again, the EU, they are one of the greatest pioneers because of my work and in the course of the regulatory work of NITDA. The EU has been a great resource as far as frontline regulations are concerned, from artificial intelligence, emerging technology, to social media, and all the other types of commerce and activities that go on online. EU has been very, very strong in terms of regulatory development, and it's been very, very impressive. Yes, some of those regulations may find difficulty in expression here in Nigeria, but it gives you a picture of what the law seeks to achieve as far as protection of persons online are concerned. So like I mentioned before, the EU came up with the guidelines on online dispute resolution mechanism in civil and administrative court proceedings. One of the things that we need to understand here is that most criminal cases do not go to dispute resolution. Those ones are handled strictly by the courts. And so basically, the EU has provided us with a what I would call guidelines on how data protection can be applied safely in a dispute resolution environment. We'll just take only those that affect data protection. The first one is the cybersecurity provision of that regulation. The cybersecurity provision says that anyone provides online dispute resolution mechanism should have some level of cybersecurity for IT products and services, processing and facilitating online dispute resolution. And you should consider unauthorized access to confidential data, which may include the products which you're selling, unwanted alteration or deletion of data, technical impossibility to access the system and the data contained therein for those who should have access, and then uncertainty over the identity of the judge and other professionals involved in ODR. So the whole essence of this is that there should be cybersecurity provisions that should take into consideration all these factors when you're dealing with online dispute resolution. Where there is identity fraud by the parties, there should be technical measures to prevent this happening. There should be technical measures to make sure that there's no uncertainty over the identity of the judge and other professionals involved in ODR proceedings. It goes on to provide certain things concerning personal data protection as well as human rights protection. It says member states should assess the impact of ODR use throughout its entire life cycle. So it's not just about carrying out the ODR activity itself, where you now share data and your data is protected. After the ODR activity, what happens to your personal data? Is it deleted? Is it retained? If it is retained, what purpose is it retained for? Who retains it? Who is the data processor? What are the rules that the person follows as far as your data is concerned? And it says the use of ODR mechanisms should not infringe data protection rights, which simply means that your data protection right is sacrosanct. It shouldn't be put in abeyance simply because you're using ODR. There should be technical and organizational measures to ensure that rules on personal data protection are respected. ODR mechanisms should be designed and developed by applying principles of personal data protection by default and by design. And in particular, implementing organizational measures to ensure personal data are protected by application of anonymization and pseudonymization techniques. Now, these techniques are used to make sure that, irrespective of the fact that the data is made available, you cannot tie that subset of data to a particular human being so as to identify them. Of course, we can use demographics when we are dealing with research as well. So these are the rules that have been set out by the Council of Europe on online dispute resolution. And the question is, will this apply to Nigeria? Legally speaking, no. But in the environment we live today, we deal with international regimes as far as electronic commerce is concerned. And so whenever, according to the GDPR, whenever you're dealing with someone who has his origins or a citizen that comes from the EU, you definitely have to apply the rules that govern them. So see a situation where the law is gradually moving away from geographical enforcement to making it personal to the citizens of those countries. And so anywhere they are, the laws which are personal from their place of origin actually applies to them as far as data protection is concerned. So for a Nigerian business, when you're dealing with ODR, you really need to find out what are the rules that govern the personal data protection of whoever is part of the ODR process. And this provides, or this actually provides a situation where you have to be extremely careful so that you will not incur any form of liability when you're dealing with people who are not citizens of Nigeria. Like I said, I never thought I was going to take up 45 minutes because the subject is interesting, and I think it would be better to actually provide more time for conversations and discussions and questions than just talking and ending it. So finally, a look at the Nigerian Data Protection Act and how it may apply to ODR. Now, the Nigerian Data Protection Act was one of the first set of laws that was signed by the current administration. The process to enact the law had commenced many years ago, and it was at the tail end of the approval that the new administration came in. And beautifully enough, the new president actually approved and signed the Nigerian Data Protection Act 2023 into law. The act applies to a data controller who is a Nigerian. And when we mean data controller who is a Nigerian, any company that is registered in Nigeria or any person who is a data controller that resides in Nigeria, such a person is part of Nigeria. And so the person must actually participate and ensure that the Data Protection Act is duly, enforced as far as the citizens are concerned. So in this particular instance, the data controller must ensure that the rules and the guidelines and the principles provided for in the Data Protection Act is duly followed if the data controller is a Nigerian, whether a natural person or a corporate personality. When the processing occurs in Nigeria, this law must be also followed. And when a Nigerian is the person that is the data subject. So if a Nigerian travels outside of the country and is a data subject, it is expected that whoever is processing his personal data, just the same way it is done in the EU, actually complies with the Nigerian Data Protection Act. Of course, the primary principle is lawful basis, and there are so many things that fall under lawful basis, an endless bucket list of issues, but the primary one here is consent. For you to process someone's personal data, you must adequately seek and obtain in a clear manner the person's consent. Of course, there are exceptions to this consent, like when you talk about health data, when the person is unable to provide the consent, issues around the child, issues where the person withdraws consent because he wants to avoid a liability as a result of contractual obligations. In such exceptions, and of course, law enforcement, even though some of us are still think that your human right is sacrosanct, and so there should be rules for law enforcement to follow as far as processing of personal data is concerned, but that's a discussion for another day. So those exceptions are not designed to abate the principles of the Nigerian Data Protection Act, but to provide exception in order to ensure that you have an adequate, what should I call it now? I'm lost for words. You have an adequate situation where nobody can use the Nigerian data protection to evade the law and also evade contractual obligations. Of course, the Act also provides the rights of a data subject. Data subject can withdraw their consent for processing even after having granted the consent, provided it does not create liability on behalf of the processor. They can also object to processing, especially if they do not have any commercial transaction. If you want to process those data and absolutely there is no way that they have any relationship with you, they can object to it. And then of course, they have the right to portability of personal data. So take, for example, if I have a telecoms company that probably has my personal data because I subscribed to their services and I decide not to subscribe to those services anymore, and I move on to another telecoms provider, I can request that my data, which is in possession of the previous ones, I don't have any business with, be removed and deleted. And then there's the issue of cross-border transfer of data. The Act provides a lot of conditions for cross-border transfer of data. It must be based on the law. Again, the primary way you can transfer personal data across international boundary is by consent of the owner of the data subject. Where there is commercial transactions also, you can also transfer personal data across border, but in certain other circumstances, you may need to consult with the commission, and you have to also show that wherever you're transferring the personal data to, even if it's for ODR purposes, that that jurisdiction has safeguards that are almost not necessarily equivalent, but minimum safeguards to personal data protection that may be equitable with the regime here in Nigeria. Of course, for enforcement of this particular Data Protection Act, you can file complaints to the commission, you can go to court, you can use ADR processes as we have discussed before, and you can also actually complain to the data controller, and if you do not receive this, the redress for the circumstances you're complaining against, you can file your complaints now to the commission. So in a nutshell, that's what the Data Protection Act is all about for now. In terms of application to ODR, this simply means that the basic rules of data protection must be adhered to whenever we are carrying out ODR processes. And where ODR environment, it creates some challenges because one of the things we've also discovered is that descriptions in law are not exactly the same type of description in technology. Let's take, for example, cross-border transfer of data. If I'm a Nigerian and I'm traveling to the United States of America and swiped, literally my data has been transferred. Sorry, can you still hear me? Okay, the Zoom just told me that internet is fluctuating or something. Anyway, so
yeah, we lost you for a bit, but we're still good.
Okay, all right, thank you very much. So in essence, when we are applying these rules and regulations, we also have to take into consideration as far as data protection is concerned. There will be, or there should be, minimum standards of security that should be afforded to personal data that is being used for ODR. And like the EU mentioned, the rules of privacy, the rules of personal data protection must be followed in every ADR practice. Like one of
Mr. Edet, I think you should turn off your video for some time. Your internet is not very good, so we've lost you again. Hello, Mr. Edet.
Oh.
I think you should turn off your video for a bit until.
Okay, can you hear me now?
We can hear you now.
Okay, so I'm going to turn off my video. And basically, I've come to the end of my presentation. That's my last slide. So I would just simply turn off the video. There you go.
Thank you very much, Mr. Edet. I think, well, you spoke for about almost 45 minutes. But at least what you should probably also do is to try to stop screen sharing. Maybe that's also part of why your internet was dragging a bit. We have a couple questions already for you. But before I take them, I don't know if there's anyone who wants to ask a question directly. I can see two questions, one from Joye and the other from Oladuni. Okay, the first says, in a case of identity theft, what steps are required by the victim to redeem his or her identity? I'm not sure that is a question for this webinar, but I'm sure Mr. Edet, if you're willing to take that, it's up to you, but I'm not sure it's then when talking about non-personal data, you made mention of some types of data some types that are considered sensitive data like ethnicity. Are there any specific distinctions between personal data and non-personal data? Then you have a third. In respect of enforcement, does the NDPC make orders to compensate a victim of data breach? If not, what options are open to the victim to seek personal redress as against fines that usually go to the government? So you have 3 questions, Mr. Edet. So you want to take them in whatever order.
Okay, can you hear me?
Yeah, and then can you stop sharing so that we can?
I thought I had done that. Oh, sorry, please.
It's okay.
Option.
Okay.
Okay, thank you. All right,
So
thank you very
take
much.
3 questions now.
Okay, I'll go to the first question that has to do with identity theft.
Okay.
The identity theft issue is totally out of this scope. But where a victim has lost his identity, in order to redeem it, I think first of all is to report to the authorities because it's very important. Your identity would be used for transactions that are that will be damaging in the long run. Because for those that run credit, it will affect your credit, affect your reputation. And so one of the first things you should do is to report the issue to the authorities. I know in Nigeria, one of the greatest means of identity theft is your WhatsApp, where people will actually hijack your WhatsApp and use it to collect money from others, pretending that you're stranded or you're in trouble. So report that to the authorities as quickly as possible. And if you can get hold of any of the accounts or numbers that is used to perpetrate the crime, do that as soon as you can. And I think the EFCC is the best place to do that in Nigeria for now. The second question is, when talking about non-personal data, you made mention of some types of data that are considered sensitive data like ethnicity. Are there any specific distinction between personal data and non-personal data? Yes, personal data are those data that actually identify you as a human being. Different jurisdictions have had different definitions of what will actually constitute personal data. But the minimum threshold is if that data can point in the direction of a natural human being, then it is personal data. Non-personal data is any other type of data outside personal data. That will be the definition I will hazard to explain about non-personal data. And personal data is divided into 2, the sensitive and the non-sensitive personal data. You can easily process the non-sensitive personal data and follow the normal rules and guidelines. But when it comes to sensitive personal data, there are additional safeguards that will be taken to process sensitive personal data. The Act actually provides a laundry list of sensitive personal data. You've mentioned one of them, ethnicity. Some would include your orientation, political views, and a few other things that would identify you as that goes beyond identifying you as a human being, but actually provides for your state of mind. So those are the kind of data that will be considered as sensitive personal data. The next one, irrespective of enforcement, does the NDPC make orders to compensate victims for data breach? Well, the NDPC has just started, so we've not seen any of their activities as far as enforcement is concerned. But Section 48 actually, Section 48 of the Data Protection Act actually provides that the NDPC, yes, National Data Protection Commission is still relatively new, so we are not yet used to the lexicon. The NDPC can actually make orders against a data processor, and it doesn't exclude orders for compensation. The only thing is that if the processor fails to comply with the orders, then it may receive sanction from the commission itself. And this sanction may require the data controller to remedy the violation, pay compensation to a data subject who has suffered injury, loss or harm as a result of that violation. You can find that in section 48 sub 2 of the data protection.
Mr. Edet, are you still with us? I think we lost you again. Mr. Edet, I think we lost him again. Okay. So I think he's answered the 3 questions until we have him back. Do we have anyone with a question? But I just wanted to make a comment as regards his contribution about the FCCPC, and to say that the FCCPC actually has a complaint portal that is used for ODR. That's just a comment. I don't know if we have any questions. I have a question for him though, but maybe, okay, he's in the waiting room. He's coming back in now. I think he's trying to use a different device. You are muted.
Sorry, I changed my device and it's still on the same network, unfortunately. I don't know what.
It's
I think the problem is with the other device.
Okay.
So, have I answered all the questions or?
Well, so far, but I have a question for you, and I don't know if anybody else has any further questions, but
Go ahead.
well, mostly practitioners on the call, and a lot of times we use ODR platforms. We're talking about data protection and ODR. What can you suggest from your standpoint as an IT person? How can we protect our clients from data protection in ODR generally? What would be your guess? Well, I know there's no one-size-fits-all answer to that, but at least what kind of precautions could we look at as practitioners?
Okay, as practitioners, I think the first thing that you should look at is the privacy policy of the ODR platform. How do they manage their personal data? What are the conditions which they use this personal data, and how do they address breaches, if any, comes up when dealing with issues around personal data protection? Having looked at the policy, you should also look at the country of origin of those platforms, because they are usually governed by the country of origin, the laws within the country of origin. Are those laws convenient enough for data protection standards globally? And if they are convenient enough for data protection standards globally, what are the specific needs of your particular client? You could have a conversation with your client. Do you want your data retained? Do you want it anonymized? Because sometimes you have reports of these dispute resolutions being archived and used for future reference when you come to precedents. Can you hear me? Okay, when you come to precedents. So do you want them anonymized? So basically you can decide your terms of engagement in terms of how you want your personal data to be handled. So first of all, determine the rights of the data subject in the jurisdiction of the ODR platform. That's number one. Number two, check out the privacy policy of the ODR platform. And if you're not satisfied and there are any special needs you need to have, you can enter into a contract with the ODR platform to actually determine how your personal data can be managed. I think with those 3 steps, you can deal with managing personal data on ODR platforms.
So Salma has a question, but I'm not sure this is for Mr. Edet. I think I might be able to answer this. It says, if I may ask, is there any specific platform that offers secured ODR services in Africa? Yes, there are several. The FCCPC, even though it's limited to Nigeria, complaints for consumer disputes in Nigeria, but there's so many other platforms that are out of Africa. And the ODR Africa Network, I know we have in the offing, we have ODR Plat, we have Webini, we have CREC, or ODR.info. There's so many platforms that you can use that provide secure services. And I purposely asked that question of Mr. Edet so that we know that all of this idea of protecting your client is universal, really. So whether you are operating out of Africa or out of Europe or out of the Americas, you still have to have behind your mind that you need to protect the data of your clients when you deal with them using ODR platforms. Because, for instance, the International Council of Online Dispute Resolution, ICODA, has certain ethical standards for engaging with ODR platforms. And so as practitioners, as lawyers, as ODR providers, as developers, as lawyers, we all must be aware of those standards and ethics that we must embrace in dealing with clients' data and using ODR platforms. I think Mirez wants to say something. Thank you, Mirez.
Thank you, Morenica. I just wanted to make a comment. Actually, I was never concerned by data protection when it comes to International Dispute Resolution Organization, but on a more general ground, using merchants' platforms, you observe actually that your data is being purchased by other organizations wanting to sell their products when you have not agreed that your data be transferred to those merchants. And it's terrible because I don't know, and maybe Mr. Edet knows or can help us. I don't know if there's a way except writing to the consumer agency and complaining about them, but then you can spend your time on doing this, because unfortunately most of the merchants violate this data protection duty.
Mr. Edet, do you want to respond to Mirez?
Yeah, thank you so much, Mirez. Again, these are some of the challenges that we face as regulators on the technology space, because you now have transactions that cut across borders. You have transactions that you cannot lay hold on the violators because they're simply not in your territory, but they're offering services in your territory, especially consumer nations like Nigeria, where we import most of the technology products that we use here. And so it portends a problem. But what we have found out is this. As far as their commercial interests, international companies tend to want to protect those commercial interests. China has done very well in terms of trying to develop their own brand as far as protecting the cyberspace around China is concerned, even though we do not have that kind of infrastructure. So what we have realized is that engagement is one of the best solutions as far as these companies are concerned. Once you find out that your personal data has been violated by a company who you may have inadvertently given your data because you want one product or the other from them, which they claim is free anyway, you realize that it is your data they are taking to sell that particular product to you. And those fine lines that you never read and you click yes, 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 you are consenting to sharing your data. But with the rights that have been provided that you can withdraw consent when you're not satisfied with the way your data is used, it's an opportunity for people to be able to talk to those platforms, and where those platforms do not respond, because even in their host countries, platforms are being forced to have what they call community guidelines now. And these community guidelines most times actually integrate data protection into the guidelines themselves. So you can use those platforms' community guidelines to seek redress as far as it's concerned. And where you do not have that redress, you can talk to your consumer protection agency which will in turn try and get those things done. What we have also realized is that there is a need for regulators to cooperate and collaborate, because technology spans across every sector. So whatever happens in one sector will affect the other sector. I like to give an example. In Nigeria, we had a problem with these loan sharks that use apps to collect money, to give loan to people. And if you do not pay the loan back on time, they will defame you across all your contacts on your phone. And it used to be horrendous and terrible to people and affected people's reputation. Now, what we found out was that the Money Lenders Act was restricted to state governments only, because I'm sure in those days it was believed that you cannot borrow money from somebody very far from you. But now, as a result of technology, you can loan money from across any country. And so it became a problem. So the Central Bank of Nigeria, NITDA, and the Consumer Protection Commission, as well as some state governments, came together to do what was then a first initiative under collaborative regulation, where we now develop regulations to cover such instances, and the regulation was issued by the Consumer Protection Commission. So regulators are getting closer to close those gaps that have evolved as a result of the use of technology, and I think it will continue to grow stronger. So a complaint to your Consumer Protection Agency will definitely be the right path to take to address such issues. Thank you.
When you know who's the perpetrator, it's often difficult to know.
Yes, that is where the problem is, and law enforcement investigation, as far as Nigeria is concerned, is still in its infant stage in the online environment. But if you can identify the perpetrator, that would also help a lot, because with a click of a button, your data can be shared to 1 million different commercial entities, and you really can't identify the origin. I agree with you as far as that is concerned.
Thank you.
Thank you, Mirez.
Thank you very much. Do we have any other questions before we round up? I don't think I see any other hand raised. Do we have any other questions? Well, if we don't, I think I'm just going to have to give Mirez the honors to say thank you to Mr. Edet. Mirez is one of our advisory board members who has joined us today. Thank you, Mirez, for your interests in ODI Africa Network. So I'm just going to ask Mirez to say a big thank you to Mr. Edet, and then we round up. We always like to stay within the hour. We have just 5 more minutes.
Thank you very much, Morinike. It's always an honor to be given a few seconds to thank the guest speakers, whom we always appreciate. And thank you so much, Mr. Edet, for the very clear presentation that have covered many items that we need to look into, either for our clients or for ourselves. So I can only thank you and echo what you all said, and thank also Morinike and ODR Africa, which is doing a wonderful job sharing with us knowledge and inviting so many learned people. So thank you very much.
Thank you very much, Mirez.
Thank you very much, Mr. Edet. Thank you, everyone, for participating, and we look forward to the next session, and we hope you will join us again at the next session, and we'll come back, Mr. Edet, because I think there's more where that came from. So we'll definitely.
All right, thank you very much.
Thank you,
problem.
everyone. Enjoy your morning, afternoon, or evening,
Right.
wherever you are in the world.
Thank
All right,
you.
thank you.
Thank you. Bye.
Thank you, ladies. Sorry,
Thank you, sir.
nice session.